Do you have a workers' compensation hearing coming up and you want to know how should I prepare, what should I do, what should I expect? Stay tuned. In this video, I'm going to go through the ins and outs of workers' compensation hearings. Hi, I'm Naomi from Gonzalez Law, legal insights from California attorneys. Today's topic, workers' compensation hearings. What are they? Why are they called? What should I expect? We at Gonzalez Law have a mission to empower clients everywhere through education on the legal process. Please support us in our mission by liking this video so more people can see it. So first of all, a hearing is called for the Workers' Compensation Appeals Board for a number of reasons. From you're not getting your mileage checked, not getting your temporary disability, not getting your treatment. There's so many different reasons people can call a workers' compensation hearing. Most of the time, it's either going to be a status conference, priority conference, mandatory settlement conference, an expedited hearing, or an actual trial. A status conference is usually the wild card. You're not sure why they're calling it unless you're looking at the Declaration for Readiness to Proceed. That will give you the reason why this is being called. Usually, these types of hearings are called when one side or the other is just not being responsive. They've set a settlement demand or an offer and it's not being responded to. There's plenty of reasons why it can be called. Now, you as a injured worker have a limited role to play in these type of hearings unless you are self-represented. In the pre-COVID days, you would go to the Workers' Compensation Appeals Board that it's being held at, to the waiting room, and wait to be called. Your attorney, meanwhile, will be going to the actual courtroom and talking to the defense attorney, then maybe talking to the judge. They'd be coming back and forth, and the defense attorney may be calling to get authority for his client, calling to get some clarity on some issues. This kind of process would happen until you finally get resolved by the judge. That judge will usually either take the matter off calendar, continue it to a different day, or have it progress to the next level, whether that's a mandatory settlement conference or being set for trial. Now, what you should wear doesn't really matter. Could wear casual wear because you're just going to be seeing attorney. You are representing yourself. You may want to wear business casual or even business wear if you are going to be going in front of the judge. But that is the pre-COVID days. So today in California, workers' compensation hearings are done via the phone. Your notice of hearing will have the judge's name as well as their number and the access number. Your attorney, check with them to see if they want you to call in. Most likely they do not. Most likely it will just be the attorney calling in and they want you to be available via the phone. They would call in and then the judge, if they want them to check with you on something, will say, okay, call in again at a later time. They'll give the time. So they'll hang up there, call you, then call back in. So it is a back and forth still in this process. If it is just a matter that is more administrative, they may not need you to hear at all for that hearing. If it's a mandatory settlement conference, your attorney may want you to be available because there may actually be a settlement offer being made. Also, you should check with your attorney to see if they need anything from you for any kind of hearing coming up. If it is going to be set for trial, they may want to see if there's any more witnesses that they should be listing or any documents that they do not already have that should be listed as their exhibits. So that's something they may want to double check with you before doing the finalization of their pretrial conference statement, getting ready to go to trial. For the future, nobody really knows what's going to happen after the court stops its COVID procedures. However, it's likely that either it will go back to how it was before COVID or maybe a hybrid structure where the hearings would continue to be taking place via the phone and the trials and expedited hearings will be done in person, but really nobody knows what's going to happen until it's decided and announced. The takeaway, though, is that your attorney should be able to represent you for any workers' compensation hearing. Most likely, they will not need you to be present or to call in unless you are going to be testifying as a witness at trial. Other than that, they usually will be the one to appear in front of the judge and then to keep you informed along the process. If you are representing yourself, then you definitely should be calling into the judge line at the time of your hearing and speaking up when they call your case name. You should also be contacting the information and assistance officer prior to your hearing so that you can know if there's something particular you need to do going into the hearing. Now, this is all general information. If you need information specific to your case, please give us a call or text this consult and we'll be very happy to discuss this with you. If you're at a mandatory settlement conference, your next step might be settlement. So what should you do? You should watch this video, which will lay out for you your settlement options with pros and cons and help you decide which one is best for you. Thank you. Bye. But really nobody knows what's going to happen until it's announced by the until it's announced.